Hello friends, welcome to Explosive Update. Today we will discuss about the criticism of fundamental rights and also we will discuss why it is required to be notified. So without wasting any time, let's begin with the fundamental right. There are 6 fundamental rights in our Indian Constitution, which is right to equality, right to freedom, right against exploitation, right to freedom of religion, right to culture and education, and right to constitutional remedies. But there are many criticisms regarding these fundamental rights. They are excessive limitations are there, where no social and economic rights are given, where no clarity is given, where it gets suspended and all. No permanence is there as it gets suspended during the emergency, having expensive remedies which a common man cannot follow, and having preventive detention and no consistent philosophy is there. So without wasting any time, let's begin to describe all this small fact in brief. So let's begin with excessive limitation. They are subjected to innumerable exceptions, restrictions, qualifications and explanations. Hence, the critics remarked that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental right should be renamed as Limitation on Fundamental Rights or Fundamental Rights with Limitation thereon. The next one is no social and economic right. The list is not comprehensive as it mainly concerns to political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic country. Also, the socialistic constitution or erstwhile USSR or China provided for such rights. The next, if we will discuss, it's no clarity regarding the fundamental rights. They are stated in a vague, indefinite and ambiguous manner. The various phrases and words used in this chapter like public order, minorities, reasonable restrictions, public interest and so on are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the Constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India as a paradise for lawyers. The next thing which we have to discuss is no permanency. They are not sacrosanct or immutable as the parliament can curtail or abolish them. As for example, the abolition of fundamental right to property in 1978. Hence, they can become a play tool in the hand of politicians having majority support in the parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of parliament to curtail or abolish the fundamental rights. Also, it gets suspended during the emergency is a major criticism regarding the fundamental right. The suspension of their enforcement during the operation of national emergency except Article 20 and 21 is another blot of efficacy of these fundamental rights. These provisions cut the roots of doctrine system by the country by placing the right of the millions of innocent people in the continent's jeopardy. According to critics, the fundamental right should be enjoyable in all the situations, whether it's emergency or having no emergency. So this is the criticism regarding the suspension during emergency. The next one is expensive remedies. The judiciary have been made responsible for defending and protecting these rights against the interference of the legislative and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critic says that the rights benefit mainly the rich section of the Indian society. The next major critics is preventive detentions. The critics assert that the provision of preventive detention, Article 22, takes away the spirit of substance of the chapter of the fundamental rights. It confers arbitrary power of the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the rights of individual against the state. Notably, no democratic country in the world has made prevention detention as an integral part of their constitution as has been made by the India. And the next one is no consistent philosophy is there in the fundamental rights. According to some critics, the chapter of fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed his view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. The critic says that this creates difficulty for the Supreme Court and the High Courts in interpreting of the fundamental rights. If I discuss one thing, that what Constitution gives with one hand, it takes away with the other, we can critically discuss with reference to the fundamental rights of the Indian Constitution. So the argument is based on the premises that every fundamental right has so many exceptions, provisions, qualification and explanation in such a way that they are rendered to exist only in the name only. Okay. The criticism is more focused on the below things. The first one is the right to equality comes with the exception, which are though positive discrimination but actually result in inequality in haves and have-nots of reservations. Second, though the fundamental rights are available against the arbitrary action of the state, but it has an exception that when the right they are available against the state's action only are violated by the private individuals, there are no constitutional remedies but only legal remedies were there. Fundamental rights can be suspended during the operation of national emergency, right to freedom of speech and expressions, which is not only fundamental right but also a human right, is also suspended. The Parliament has tempered that the fundamental rights, for example, reducing right to property to a legal right, that is given in Article 31. The provision regarding prevention detention makes right to freedom hollow. These are also a view that the constitution makers also fail to incorporate certain rights such as right to work and employment, though it is desirable. Whether it could have been sustained in the conditions of scarcity found in a country like India. Moreover, it is felt that the legal terminology surrounding their provision in the constitution is extremely difficult for the common man to follow. Though the restriction of fundamental rights are sometimes difficult to defend, it must be remembered that our democracy has never been able to free itself of certain major stresses and strains. And when the defense and security of the nations are of utmost significance, these limitations have to be taken in other stride. Nevertheless, much depend on the citizens' consciousness to keep the rights alive. Only that would be the true mark of authentic democracy. So guys, these are my views regarding the fundamental rights. If you are having, comment below. That's all for today. We'll meet you soon in next such update.